Rule 615. Rule 615. This is Colorado Rules of Evidence. Rule 615, exclusion of witnesses. At the request of a party, the court shall order witnesses excluded so that they cannot hear the testimony of other witnesses. And it may make the order of its own motion. This rule does not authorize exclusion of one. This rule does not authorize exclusion of one, a person who is a natural person, or two, an officer or employee of a party which is not a natural person designated as its representative by its attorney, or three, a person whose presence is shown by a party to be essential to the presentation of his cause. A person whose presence is shown by a party to be essential to the presentation of his cause. So they're saying you can't exclude a person, right? We're looking for the truth. We're looking for clarification in the truth. That's what Rule 614 is saying. Calling an interrogation of witnesses by court. When can the judge ask a question of the witnesses? Whenever the hell he wants or she wants to. Whenever the hell they want to. So the judge can ask the witnesses questions. The judge can exclude witnesses. You can have admissible evidence, relevant, material, admissible evidence, and then there's inadmissible evidence. But anything tending towards the truth, we need clarification of your testimony or to get to the truth, to get to the bottom of things. So again, Rule 615, exclusion of witnesses. At the request of a party, the court shall order witnesses excluded so that they cannot hear the testimony of other witnesses, and it may make the order of its own motion. This rule does not authorize exclusion of one, a party who is a natural person, or two, an officer or employee of a party which is not a natural person designated as its representatives by an attorney, or three, a person whose presence is shown by a party to be essential to the presentation of his cause. Federal rule is identical. I'm just going to read all this in annotation. There's a lot here. This whole page is annotation. And then we're going to get to 700. Article 7, opinions and expert testimony. Rule 701 is opinion testimony by lay witnesses. But first, we're still doing Rule 16, exclusion of witnesses. Exclusion of witnesses. Annotation, law reviews. For Article A, deposition primer, Part 1, setting up the deposition. 1982. For Article 6, Rule 615, exclusion of witnesses. There's an article, 1995, 24 Colo Law, 1299. For article, the ethical preparation of witnesses, see 42 Colo Law, 51 May 2013. Policy reasons for sequestration rule are to prevent a witness from conforming his testimony to that of another, and to discourage fabrication and collusion. Martin v. Porak, 1981, Colorado Appeals. Purpose of rule is accomplished under rules terms by ordering witnesses to withdraw from courtroom until called. However, to make the rule effective, court may also direct witnesses not to discuss the case with each other. People v. Brinson, 1987, Colorado Appeals. This rule applies only to witnesses, not attorneys. Thus, an attorney's discussion of one witness's testimony with a prospective witness does not violate the rule. Thus, an attorney's discussion of one witness's testimony with a prospective witness does not violate that rule. People v. Villalobos, 2006, Colorado Appeals. A court has discretion in appropriate circumstances to grant an exception, allowing a witness to impeach the testimony of a criminal defendant after hearing the defendant's testimony. Trial court properly granted exception to sequestration order by allowing prosecution's toxicologist to hear defendant's testimony and testify in response thereto. People v. Scarlett, 1998, Colorado Appeals. For the purposes of determining who may be excluded from a pretrial deposition, CRCP 26C5, and not this rule controls. Hammond Contractors Incorporated v. District Court, 1994, Colo. When denial sequestration mandates new trial, trial court's error in denying a sequestration request does not mandate a new trial unless the requesting litigant demonstrates that the error constitutes sufficient prejudice to amount to an abuse of discretion. Martin v. Porak, Colorado Appeals, 1981. Williamson v. School District Number 2, SCH. Williamson v. School District Number 2, 1984, Colorado Appeals. Corporations, officers allowed to remain in the courtroom, although witnesses who are officers of a party corporation are not formally designated as representatives. The trial court may still allow the witnesses to remain in the courtroom. Jefferson Western Court v. Chiefas, Colorado Appeals, 1983. Rule prohibits the sequestration of an officer or employee of a non-natural party. Non-natural party. A dog who has been duly designated as its representative. You are not a natural party. What is a non-natural party? People v. Cheeks. People v. Cheeks. Colo, 1984. Determination of whether there's been a violation of a sequestration order and the penalty or section to be imposed are all matters resting within the discretion of the court. People v. PRG. Colorado Appeals, 1986. Where the trial court simply ordered district attorney to tell his witnesses not to talk to each other about their testimony. The sequestration order had not been violated when the prosecutor talked to his witnesses in a group prior to presentation of any evidence. People v. Brinson, 1987, Colorado Appeals. It is in the trial court's discretion to determine the appropriate penalty for a violation of a sequestration order. People v. Johnson, Colorado Appeals, 1988. In determining whether to impose sanctions for violation of sequestration order, court must consider three things. 1, the involvement or lack thereof of a party or his counsel in the violation of the order. 2, the witness's action and the state of mind in his violation of the order, and whether the violation was inadvertent or deliberate. And 3, the subject matter of the violation in conjunction with the substance of the disobedient witness's testimony. People v. PRG, 1986, Colo Appeals. Test applies in People v. Melendez, 2003, Colo App Appeals. Affidavit on other grounds. Aft, AFF apostrophe D, aft on other grounds. Colo, 2004. The Supreme Court modified the first factor set forth above to require evidence of the parties or counsel's consent, connivance, procurement, or knowledge regarding the violation before a sanction can be imposed against that party. People v. Melendez, Colo, 2004. In determining whether to impose sanctions for violation of a sequestration order, the trial court must consider, in addition to other things, the subject matter of the violation in conjunction with the substance of the testimony of the disobedient witness. Also, in order to prevail, the defendant must show that the witness's testimony would have been different but for the conversation which violated the court's order. People v. Johnson, Colo, App, 1988. Sanctions for violation of a sequestration order, in addition to a mistrial, fall into 3 categories. 1, citing the witness for contempt. 2, permitting comment on the witness's non-compliance in order to reflect on his credibility. Or 3, refusing to let the witness testify or striking his testimony. People v. PRG, Colo App, 1986. Sanctions for violation of a sequestration order in addition to a mistrial fall into 3 categories. 1, citing the witness for contempt. 2, permitting comment on the witness's non-compliance in order to reflect on his credibility. 3, refusing to let the witness testify or striking his testimony. People v. PRG, Colo App, 1986. It was an abuse of discretion to impose the extreme sanction of witness exclusion without an inquiry into the factors governing the imposition of such a sanction, and in particular without evidence that the defense was at fault for the violation. People v. Melendez, Colo App, 2003. Affidavit, Aft, Colo, 2004. Prejudice resulting from violation of a sequestration order. Sequestration. It's 4 syllables. I kind of want to say it like it has 3 or maybe 2. Question. Prejudice resulting from violation of a sequestration order must be shown in order to require granting of a mistrial. People v. PRG, 1986, Colo App. A victim's right to be present at all critical stages of the criminal justice process under Constitutional Article 2, Section 16A. Whoop, whoop. That is nice. Constitution Article 2, 16A. I've never seen it actually. That's how I do the notation. That's crazy. So me and this big ass book do the because victims' rights comes from 24. There's statutes and then there's the Constitution. So victims' rights comes from CRS 24 4.1 302.5 1D apparently. So very fucking specific. A lot of points. 4.1 302.5 and then 1D. But it comes from our Bill of Rights 16A. So I guess there's a 16 and then there's a 16A. Or maybe a 16B. A victim's right to be present at all critical stages of the criminal justice process under Constitutional Article 2, Section 16A and 24.4.1.302.5 1D takes precedence over a party's right to sequester witnesses under this rule. The father of a murder victim who testified in the defendant's trial was wrongly excluded from subsequent portions of the trial. People v. Coney, 2004. Colo App applied in People v. Beltran. Colorado App, 1981. So there you go.